Ah, good afternoon. Notice we're not-
Good afternoon, Your Honor.
How are you doing?
Good, thank you.
Ms. Martinez, you can hear me?
Yes, sir. Hi.
Okay, we're here on a motion to compel. I've reviewed this and I just want to make sure that I'm on. Mr. Hernandez, you sued Ms. Martinez on a sublease? Oral sublease?
Yes. Yes,
Okay, and you're suing her for $1,600.10 and 53 cents.
that's correct, Judge.
Okay. We have an Annette Sanders. Who is Annette Sanders?
Ed Sanders is the, I guess, regional or area supervisor here for State Farm offices. But I didn't include her on the petition.
Who called her?
Hello. Hello. I had requested for her to listen in since you asked if I had any witnesses.
I'm talking about witnesses at the bench trial.
Okay.
I mean, she's welcome to listen in, but I mean, I don't know
Okay.
what she's relevant to today.
Okay.
Well, Judge, I would, at this point also, I'd invoke the rule then if she's gonna have her listen in.
As far as I know, she's invoked the rule as far as being a witness today.
Right, I mean, I don't want her to participate at all in this hearing if she's gonna testify in the future.
Well, the problem is, I mean, as you know, courtrooms are to the public.
Right, well, then I would call her as a potential witness, Your Honor, and I would invoke the rule.
You're going to call her as a witness today?
As a potential witness, yes, and I would invoke the rule.
Okay. Are you going to call her as a witness today?
I may, I don't know, Judge. Depends what goes on throughout the hearing.
Okay. Well, how do I stop her from listening to a hearing?
You could put her in a breakout room, I guess. And if we were in person, you would instruct her on the motion, on my motion to invoke the rule, and she would be escorted out of the courtroom.
Okay, if you're going to call her as a witness, let's call her as the first witness then.
Well, I don't know. I may call her as a rebuttal witness, depending on what happens during the hearing.
Okay. Okay, Ms. Sanders, I'm going to place you out in the waiting room. Let me figure out how to do this. And we'll call you back in. Okay. Okay, so here we're on a motion to compel. I've gone through this. You have, I note that there were answers to it. I'm treating these answers as the ones that weren't answered as to objections. And we'll just go through them and see if they are relevant. So, Mr. Hernandez, the first one is, let's go through, I guess, the admissions. What is your first admission that you state that she didn't answer?
Your Honor, the main ones that I would like the court to consider on the request for admissions would be number 10, 15, and
Okay, let's
19.
take it 10. Admit or deny the CAM fees for the property located at 1470 George Dieter, Suite B, El Paso, Texas, are owed for dates January 1st, 2019 to August 31st, 2019. And she answered, not applicable to me. Lease agreement is between Ruben and Lord, and I was not part of lease, I think it says.
That's correct, Judge.
So she's not part of that lease.
That's deemed, again, Your Honor, I have a case law here, Marshall v. Vice, 767 Southwest 2nd, 699. And it says that requests are automatically deemed admitted as a matter of law on the day after answers are due if no answers, objections, or assertions of privilege are served. So
I'm treating this, as if she objected to the question. She objected to answering it. So we're just determining whether it's relevant or not.
so you're ruling that she
If you
denied
send-
that?
If you send discovery to somebody, they can object to answering it, grounds that it's not relevant or other grounds for not answering it. That's what I'm treating this as, is she's objecting to these. So now we're going to
Well,
make
okay,
whether it's relevant.
well then let's go number 15.
Okay, so we're not, drop 10.
Well, if you're ruling on it, I don't agree with, I don't think that she's given a legal basis or a legal objection
Okay,
in her response.
she's not an attorney.
Number 10.
You know, I'm treating these as.
Well, I know,
questions. Okay, so
maybe she should have hired one.
which one were we going to?
Number 15, Your Honor, is pretty clear cut.
Admit or deny that Crystal Martinez has not performed her contractual obligations required by the contract between the parties. What parties?
The parties, us, that are included in this lawsuit,
Who are the, just you and her?
just me and her.
Okay.
And she puts not applicable.
Okay, because it's confusing to me, because you asked earlier, admit or deny that State Farm Insurance is a party to the contractor agreement. And number 5. No, I'm sorry, number 6.
Well, she can admit or deny it. She could deny it, Judge. She doesn't deny it.
No, that's not my point. My point is, what contract are you referring to?
The contract between the parties in this case,
The oral contract.
the party, State Farm is not a party to this case.
Okay, so the oral contract.
Yes,
Okay.
yes, sir, that's correct.
15, admit or deny that Crystal Martinez has not performed her contractual obligations required by the oral contract between the plaintiff and the defendant.
Correct.
Okay, I can order that. You can answer that, Mrs. Martinez. I'm going to revise the admission so that it's clear what contract you're referring to. Admit or deny that Crystal Martinez not performed her contractual obligations required by the oral contract between Ruben Hernandez and Crystal Martinez. Okay, what other one?
Number 19,
Excellent. Admit or deny that the contract between the parties limits the liability of defendant to 1610. What contract?
the oral contract. That's listed in the petition, Your Honor. There's only one contract that's spoken of in the petition that she was served with.
Well, I don't understand that myself. Admit or deny that the contract. So when you're saying when you first negotiated this, that you said your limits of your liability to 16, you knew what the CAM was, what the CAM was not going to be paid at that time?
No, Your Honor. The breach that she owed on this contract was 1610.
If you say limits, admit or deny that the contract, you made the contract orally back in, I think, December
Yes.
of 2019.
18.
18. You told her at that time the limit of your liability is 1610?
Okay, I'll strike that, Judge.
Okay.
We
Any other?
can go to the, no, we can go to the, I still think on number 15, she admits that she has not performed her obligations under our contract, which was listed on the petition between the
well,
parties. And
Okay,
that solves the whole case.
okay, well, okay, so the, what I'm ordering on this, and Ms. Martinez, is it Ms. Martinez? Yes, Ms. Martinez, you understand that you're ordered to answer, admit or deny that Crystal Martinez has not performed her contractual obligations required by the oral contract between Ruben Hernandez and Crystal Martinez. You either have to admit or deny that. Okay?
I guess I don't understand, Judge, because there was no contract or agreement between myself and Ruben Hernandez. So that's why I put not applicable, because there was no contract between myself and him.
You didn't agree to take, I assume Mr. Hernandez was liable on the lease with
EP Shalom.
AP Shalom. And you didn't agree to take over the obligation, or did you have any agreement with Mr. Hernandez?
No, sir. My State Farm hired me as a rescue agent. He was terminated in December. State Farm called me, and I've done this for State Farm 3 times now. Ruben Hernandez job, right, to manage that location was with me and State Farm. My agreement was with State Farm hired me, State Farm paid me. I had really no agreement with Ruben or EP Shalom. I never signed a lease. I didn't take over a sublease. I did none of that.
Okay, so your contention on 15, there is no contract between you and Mr. Hernandez.
No, sir.
Then we're going back to your prior ones, and you say, admitted, I deny that the parties had an oral contract which we performed and completed with 1 year. And you deny, okay, well, you denied it back then, okay. Okay, then you would have to answer, I cannot admit or deny because there's no contract.
Exactly. And like I said, I didn't understand how to respond as I put not applicable. It doesn't apply because State Farm hired me after he was terminated. And I've done this for State Farm 3 times now, done this before. I've never had any issues in the past. So maybe he didn't understand what was going on. I thought I was helping. I mean, I have been helping the company for a long time. I thought Ruben would be grateful for me taking over.
She's going to testify, Judge, and I want to cross-examine her. She's going to testify.
You can go ahead and respond.
Judge, this case is very simple. I was an agent. They terminated my contract on my contract. They terminated the contract. She took over the lease, and she agreed to take over the lease and everything that goes with it, the CAM fees. That's why she paid the lease for the following 10 months, because she agreed to do that. She paid it. I get a letter from EP Shalom that says there's CAM fees owed from those 10 months. So I sent it to her and the agent who also took over the property there after Crystal. The other agent paid her part. Crystal didn't want to pay her part, saying, I have nothing to do with that. I already paid the contract for 10 months. I said, no, this is part of the contract. This is part of the CAM fees. I wasn't there. She benefited from using that office for 10 months, and State Farm paid her for being there and using that office building, and they paid her hundreds of thousands of dollars to be there, Your Honor, and she doesn't want to pay $1,600. This is a court of equity. She needs to pay because she benefited from the use of that building, and that's why I want her bank records, because I want to show the court how much thousands of dollars she made from running that office out of that location on George Dieter.
Wow.
So you're all wanting to argue the case. I'm just talking about this one request for admission right now, number 15. And from what I understand is, Mr. Hernandez, you're contending that there was an oral contract between you and Ms. Martinez, and Ms. Martinez is denying there is.
There was.
And Ms. Martinez is denying it.
That's correct.
That will be decided at the hearing. Okay, so from what I understand, this 15 is that you're saying there was no contract, so you can't admit it or deny it.
No, sir, there's no contract between Ruben and I.
Okay, so then I'm not going to order anything on the admissions. Let's go to the next one you have, Mr. Hernandez.
Okay, we have the motion to compel.
Okay, on the interrogatories or production?
And there's one interrogatory, and then there's several requests for production, and they're listed on my motion.
What is the interrogatory you want to take up?
number 8.
State the amount of total financial compensation received by you and State Farm Insurance Company the dates January 1st, 2008 to December 31st, 2000. How is that relevant?
Judge, because that shows the amount of money that she received for running that office. When she took over my office, she used that office for the benefit, and she made gains during that time by using my office, because that was a contract that we had between each other, is that she was going to use my office to continue to run the State Farm business, and she was going to pay the rent on that office along with the camp fees.
So if she got paid $1 from State Farm, how would that be relevant?
Well, I need to show the court, Judge, that she received a benefit from the contract that we had. Because I have to show the
If you
court
had
that-
it, if you had a
the
contract,
office-
if you had a contract, it's just what the contract is. If she agreed to take over the payments, she agreed to take over the payments. Whether she got paid $1 from State Farm or whether she got paid $200,000 from State Farm. How's it?
Well, I think since this is a court of equity, Your Honor, I think it's important to see that the court can see what she benefited from having used that office for 10 months, and what we're asking for under the contract, what she should pay. If this is a court of equity, I think the court should take that into consideration.
I find it's not relevant. Let's go to the next one.
Well, everything else deals with the request for production, deals with her income and her bank statements. Why I need to know, well, we want to show the court how much money she's made from State Farm, because this is a court of equity.
I still don't see the connection there. You're saying it's a court of equity. What difference does that make to what she makes?
Because Judge,
If she makes a lot of money,
the
that
court has,
she should have to pay somebody?
well, because the court's going to see how much she benefited from using the office building, the lease that I had. She took it over so she could continue to make that, to help State Farm and make thousands of dollars using that office.
Okay,
That
so if
office
she
is
lost-
bringing in
If she lost money,
$1,000 a month.
if she lost money, she wouldn't have to pay you?
No, Judge, but again, this is a court of equity. I know that she's made that office, when I left that office, it was making $20,000 a month. And she made that for 10 months. And now we're asking her, as part of our agreement, she was gonna pay the lease. She paid the lease every month. She was paying the camp fees included. And she was paying the bills. She was paying the utilities. These camp fees that she was paying were fees that were, they weren't final. So every year then, EP Shalom gives you the final notice of the camp fees. So these camp fees were for the months that she used that office.
Right, which should be,
So she owes that
if there is an agreement, if there's an oral contract between you, should be required to pay whether she lost money or made money. Didn't make any difference.
I just thought it's important for the court to look at that, since this is a court of equity.
Okay, no, I don't find this relevant.
We just need to set this for a final hearing, Your Honor.
Okay,
Because all the other requests for production deals with the same issues.
okay. Is there not a setting?
I don't think we have a setting.
Let me see.
And Judge, since Ms. Sanders is here, I'd ask the court that she be attached so she can testify at the final hearing. Because she was present
Attached to what?
when we agreed to.
What do you mean attached?
Well, so she can appear at the next court hearing to testify, so we don't have to subpoena her.
Well, if you want to, is she subpoenaed right now?
No, but she's here.
Okay, well, if somebody wants to subpoena, they can subpoena her. Either side could subpoena her. Yeah, there is no setting. Let me see if I can get Ben. Hi, Ben. You there? Let me get, hold on. Okay, I think Ben should be joining us. One second. How far off do you want a setting, or soon, later, what?
Soon as possible, Judge.
Okay. Maybe I have to get him on the phone. Ben,
Hi, Judge, I'm on.
okay. So we need a setting, a bench trial setting
Okay,
as soon as possible, or
sure.
how long do you think it's going to take? Parties.
It'll take more than an hour, Judge. Pretty simple facts.
Ms. Martinez, you agree?
Yes, sir, it's very simple. I agree.
Okay. So now,
Okay. Judge, I have June 8th. We can do it at 9 a.m. I don't have anything. We have a session that starts at 10, but we have 9 a.m. on June 8th.
okay. June 8th at 9 a.m. work?
It works for me, sir.
Yes, Judge.
Then June, wait, am I looking at the calendar right? Let's see. I show administrative hearings, Ben.
At that time, let me
What-
check again, Judge. Let me
What
just-
time? What time did you say?
9 a.m.
I show administrative hearings at 9 a.m. June
Okay, you're right, Judge. I missed that one. I apologize. Let me see. June 8th, 10, 11:45. So, I mean, we could do 8:30
8:30 when?
on June 8th.
Okay. Does that work for the parties?
Yes, sir.
Sure, Judge.
Okay, we'll do June 8th at 8:30.
Okay.
Okay.
I'll reset it. I'll reset it with the
Zoom in.
same password. Same password and same login.
Okay.
Okay,
Thank you.
thank you all.
Thank
Do we have
you.
anything further?
Nothing further, Your Honor.
Okay, I'm going to end the hearing. We'll see you on June